friends, Namaskaram. How are you? Jai Mahakal, Jai Shri Ram. In today's class, we will study about section 353 of BNS. Are you having any idea about the same? So basically, a lot of controversy has been arisen concerning section 353 of BNS. But the primary question arises, what are the controversies and why they have been arisen? So basically, we have to understand the basic concern. We have to understand the basic cause so that we could understand the effect and could have the effective solution on the board. Basically, whenever we internally publish a content on social media, it might be Facebook or YouTube. The content might affect the public at large. It might affect the political parties. So basically, the allegation might be that with your content, yeah, in consequence of your content, the public peace had been disturbed, the trans equality had been disturbed. Your publication is having the offensive effect, and apart from that, your content is quite critical. You are having intent to disturb the public peace in consequence of that. So ultimately, you might be triggered concerning Section 353 of BNS. But Section 353 of BNS is never applied in isolation. Along with the said section, there might be a possibility that Section 351 of BNS or Section 352 of BNS or Section 67 of IT8 could be imposed. So, whenever we are having the FIR, there is no need to be in anxiety or panic. We have to observe certain steps so that we could easily neutralize the allegation against us. If you really want to understand and really want to update your information or knowledge on the subject, I request all of you to maintain the proper notebook. Okay. We will discuss the important judgment of Honorable Telangana High Court that is dated 10th of September 2025. In that case, the accused was prosecuted as per Section 353 of BNS, and along with BNS, Section 67 of the IT8 is also imposed. So basically, it is submitted by the concerned accused that he never intend to purge or to upload any material that may affect or that may disturb the public peace. He submitted that mere publication of any material would not be sufficient to bring the prosecution of Section 353 of BNS into motion. He submitted that he never published any content that is highly critical, having the high potential effect, and inter alia, it may result in the breach of public peace. So basically, he submitted that it is a mere publication. He is having no intent to do the same, and that's why the FIR is nothing but abuse of process. But whenever we argue in the court of law, it is not easier task. We have to convey to the honorable court that the prosecution itself is false from the inception, and apart from that, we have exhausted the legal remedies. But the concerned IO, concerned police is not going to cooperate us. Rather than they are going to arrest us. So we have to understand that as per Article 21, the right to life and right to liberty are fundamental rights, and it could not be compromised and it could not be suppressed by any means. The process must be the due process. If the process is not the due process, in that scenario, we could have the benefit. So, whenever we are going to argue our petition concerning Section 353 of BNS offence, simply we have to understand the FIR. We have to submit the proper memorandum or gyapan to the concerned police in which we have to specify that we are having no intent to disturb the public peace, and apart from that, we are having no intent to publish any material that is offensive or it is having the similar effect. So basically, the intention is important. If the intention is not proved and there is nothing on the record to corroborate the factum of intention, we could have the benefit. So basically, the law itself provides the protection. It says if the publication is true, it is in good faith, it is for the public good, and there is nothing on the record to suggest that you are having any intent to disturb the public peace, you could claim the immunity and could claim the remedy as per the protocol of the question. So if there is purging or spreading of any information, it might be the alarming news. So basically, you develop the enmity, the feeling of hate, the feeling of ill willing among the member of the community. In that scenario, you could be prosecuted. So if the content of you never induced any discrimination based on religion, race, place of birth, residence, language, caste, or community, you could have the benefit. In addition to this, we are having one of the most important judgment of Honorable Telangana High Court, that is 21st of April 2025. In that case, the said principles are approved by Honorable High Court. So whenever we are having the case against us concerning Section 353 of BNS, simply making a submissions is not sufficient. we have to specify that we are having no intent, and apart from that, we are having no rule. If your arguments are general, unspecific, in that scenario, we could not be succeeded. So first of all, we have to understand the FIR. We have to point out what is our role, and we have to point out how we are falsely implicated. If your submissions are not effective, the submissions are general, and they are made without any basis, in that scenario, you could not be succeeded. Simply, the defense has to sustain that the prosecution is false from the inception, and that's why the thorough study of the prosecution case is quite important. So simply, we have to specify that we have taken the copy of the FIR, inter alia we submitted our representation, but it was not considered, and ultimately IO is working in the biased manner. So in that way, we could have the benefit. So from the root we have to start so that we could have the proper remedy. So if we are able to specify that the allegations are true, the allegations are imputed in the good faith, it is for the public good, then we could have the benefit. And apart from that, if you could specify that the information spread by you is neither false nor rumor nor alarming news, in that scenario we could have the benefit. So law never intend to punish you. Law says that whenever you violates the rules and regulation, in that scenario you could be prosecuted. So if you have not violated any provision of law, the prosecution instituted against you is abuse of process. In that scenario, we could have the benefit as per the judgment of Honorable Telangana High Court, that is dated 10th of 9 2025, and other one is 21st of April 2025. In both the cases, specific principles are given to contest the cases which are covered as per section 353, subclause 1, subclause B of BNS. So in that scenario, or with that modus, we could work out and could avail remedy as per law.